Hello everybody. Today we will be discussing about module 3, and our very first topic is common intention and common object. Now this common intention and common object owes its origin to the doctrine of combination, which states that whenever a crime is committed by a group in furtherance of common intention or common object, each member of such group will be liable for that act in the same manner as if it was done by him alone. This is what your doctrine of combination is, and this doctrine of combination is the basis for your penal provision of common intention and common object. So first of all, we'll be discussing about common intention. Now, as we all know that common intention has been given under section 34 of the Indian Penal Code. Now, brief history about it is that when you come across this word, in furtherance of, this word was added after Privy Council's judgment in Ganesh Singh versus Ram Raja 1869 to BLR 44 PC, wherein the Privy Council quoted that where parties go with a common purpose to execute a common object, each and every one becomes responsible for the acts of each and every other in execution and in furtherance of their common purpose. As the purpose is common, so must be the responsibility. And after this judgment, this word furtherance of common intention of all was added. Now, the next question is that what are the essential ingredients of section 34? That a criminal act must be done, it must be done by several persons, and the next requirement is that they should have a common intention to commit an offense. Now, what does common intention means? Common intention means prior meeting of minds, a preconceived design or a plan. The term common intention should never be confused with similar or same intention. Both the words are different from each other. No. Now, when we are talking about section 34, now we'll be discussing some of the landmark cases in this respect. To name a few, a very leading case is that of Mehboob Shah versus Emperor, which is also known as the Indus River case. The citation is AIR 1945 PC 118. In this case, one accused named Allah Dad, along with few others, went to cut and collect reeds on the bank of the river Indus from the land belonging to one person named Muhammad Shah, who was the father of Wali Shah, who later absconded. Now, Muhammad Shah at that time was taking bath in the river. Allah Dad, in spite of repeated warnings from Muhammad Shah, collected reeds and started the journey. In the meantime, other person named Ghulam Qasim, who was the nephew of Muhammad Shah, arrived at the spot and tried to snatch the bundle of reeds from the deceased's possession and also gave him a blow with a stick. Consequently, Allah Dad picked up a bamboo pole and struck the nephew of Muhammad Shah, who shouted for help. Wali Shah and Mehboob Shah whereupon appeared on the scene with loaded guns in their hands. When Allah Dad and his companion Hamidullah tried to escape from the scene, Wali Shah fired at Allah Dad, who fell down and died on the spot. Mehboob Shah also fired at Hamidullah, causing injury to him. The Privy Council found absence of common intention in this case, but when the appeal was made, a disagreement was made by the High Court, and it stated Section 34 lays down a principle of joint liability in the doing of criminal act. The essence of liability under the section is to be found in the existence of common intention animating the accused, leading to the doing of a criminal act in furtherance of such intention. The High Court further added, to invoke the aid of Section 34 successfully, it must be shown that the criminal act complained against was done by one of the accused persons in the furtherance of the common intention of all. If this is so, then liability for the crime may be imposed on any one of the persons in the same manner as if the act was done by him alone. It further held that this being the principle, it is clear that common intention within the meaning of section 34 implies a pre-arranged plan, and to convict the accused of an offence applying the section, it should be proved that the criminal act was done in pursuant to the pre-arranged plan. This is what it was held. Now we'll be discussing what are the differences between common intention and same intention. To constitute common intention, it is necessary that the intention of each person should be known to all the others who are a part of it. But this is not the case in case of similar intention. Now, this distinction was discussed by Supreme Court in the case of Pandura versus State of Hyderabad, AIR 1955, Supreme Court 216. The facts of the case were that there was one person named Ramchandra who had gone to his field to pick up chilies with his wife's sister Rasika Bai and his servant Shubhana Rao. Rasika Bai and Shubhana Rao were picking up chilies in one field, and Ramchandra in other field was in another field who was picking them up. A little later, Rasika Bai, on hearing some alarm from that direction where the Mr. Ramchandra was, she went along with Shubhana Rao. They saw all the 5 accused attacking Ramchandra with sticks and axes. Rasika Bai protested against the assault, but they threatened her of grave consequences. Ramchandra died almost on the spot, and all the 5 persons were prosecuted under section 302, read with section 34. The conviction of the appellant for murder was set aside by the Supreme Court on the following grounds. Several persons can simultaneously attack a man, and each can have the intention, namely the intention to kill, and each can individually inflict a separate fatal blow, and none would have the common intention required by the specific section, because there was no prior meeting of minds to form a pre-arranged plan. In a case like that, each would be individually liable for whatever injury he has caused, but none would be vicariously convicted for the act of any others. And if the prosecution cannot prove that his separate blow was a fatal one, he cannot be convicted of the murder. However, clearly an intention to kill could be proved, he can be convicted for common intention. But until and unless the prosecution has proved that it was his blow only which led to his to the death of the deceased, he cannot be convicted for murder. Now, this is your about common intention under section 34. Now, this takes us to our next topic, which is the common object. But before we move, it's important to again revise what are the important points under section 34. The principle underlying section 34 is that as the intention is common, the liability must also be common. Where section 34 applies, the liability of the person liable by virtue of the section is not the liability as an abettor, but it is the liability as a principal. Similarly, participation in the act and common intention are 2 essential ingredients of this section. Section 34 applies even if cumulative effect of injuries be of nature sufficient in the ordinary course of nature to cause death. And in order to attract section 34, what is important is that there must be a pre-arranged plan and meetings of minds. These are some of the important points which we should keep in mind as regards section 34. Now, we have discussed about section 34, so now we'll be moving over to common object, which is our next topic. Now, to quote section 149, what it states is that every member of unlawful assembly guilty of offence committed in prosecution of common object. If an offence is committed by any member of an unlawful assembly in prosecution of the common object of that assembly, or such as the members of that assembly knew to be likely to be committed in prosecution of that object, every person who at the time of committing offense is a member of the same assembly is guilty of that offense. So this is your common object. Now the question arises, what is unlawful assembly? The answer has been given under section 141, which states an assembly of 5 or more persons is designated as an unlawful assembly if common object of the persons composing that assembly is, first of all, to show criminal force to the central or state government or any public servant, and also the parliament or state legislature, to resist the execution of law or any legal process. Third, to commit mischief of criminal trespass or any other such offense. Fourth, to use criminal means and to obtain property by use of such means. Fifthly, to use criminal force to compel any person to do an act which he is not legally bound to do. So this is your unlawful assembly. Now, an important case in this regards is in Moti Das versus State of Bihar, AIR 1954, Supreme Court 567. An assembly which was lawful became unlawful the moment one of the members called on the others to assault the victim, and in response, members of assembly started to chase the victim while running. It may turn unlawful all of a sudden and without previous consent among its members. That is pre-consent, pre-arranged plan or meeting of minds is not necessary under section 149. Now, the essential ingredients of section 149 are that there must be an unlawful assembly, as we have discussed under section 141, which defines it. The criminal act must be done by a member of such assembly. Act done is for the prosecution of common object of the assembly or such which is likely to be committed in the prosecution of common object. Members must have voluntarily joined the unlawful assembly and knew the common object of the assembly. Now, the question arises that what is the term in prosecution of common object? What is its meaning? Now, in Queen versus Sabid Ali, 11 BLR 347 is the citation. The words in prosecution of common object were construed as with a view to achievement of common object. So in prosecution of common object means with the view to achieve any common object. This is what this section means. Now, this was your about common intention and common object. We have provided you with the material also, and if there is any confusion or any question as regards it, you can please drop your query and we will answer that.